I welcome you in my third lecture regarding the fundamentals of legal compliance for incorporating startup. More specifically, I will concentrate my talks on comparative analysis of compliance requirement within the different business form. So, what I did, I have created a table for you which will give you a clear picture regarding the compliance which you need to do regarding the different business form. And to do that, what I did, I put the form of the business in the left side of this particular table. So, you can easily identify which business form I am talking about, and then I have put several criteria into from left to right. One is formation documents. What kind of a document you require for incorporating the business form? And you will be surprised to know that there is some of the cases there is a legal requirement, and in some cases there is a no as such legal requirement. Similarly, I have talked about verification of the promoter's credential, and this is become very important nowadays if you are incorporating any formal business form, because you might heard about the vanishing companies, and vanishing companies are really creating a lot of trouble into our economy, and there is a lot of defrauding to the people after taking the investment from the people at large. So, the government has come up with different mechanism to arrest this kind of a vanishing companies or vanishing organization. So, now the credential verification is one of the important thing while you are going for incorporation of a business. Next is filing of incorporation document with registering authority, and you will find for the different business form there is a different registering authority. Some of these particular registering authorities are administered by the central government or monitors by the central government, and some of them are monitored by the state government, and they have a designated offices in the different city and different within the different states, or maybe in multiple city within the different states. Now, some of the law also prescribes that you need to specify the business objective or in which are the area you wanted to carry forward the business, and what are the ancillary business you wanted to carry in addition to your main business. So, you need to have a upfront declaration relating to your business at the time of the incorporation, but this is not necessary for all type of the business form. So, that is the reason I have created a column for that. So, it can give you a clarity in this regard. Similarly, you will find you need to have a business capital, and some of the law specifies that you have to upfront tell that what should be your authorized business capital in the subsistence of your organization. Authorized business capital means that if you are not amending your capital clause in the constitution document or formation document, then you cannot raise more fund or more capital than that. So, you also require to disclose your registered office. That means, if somebody wanted to communicate with you, you need to have a definitive address, and law specifies that. Like if it is a Companies Act, then you will Companies Act insist that you have to have a register office, and register office need to be written into your constitution or formation document. And then in the last column you will find I have given you a governing laws. So, under which laws this particular business firm governs, under the which law it governs. Now, this is a induction process. I am just inducting you gradually into this particular understanding. So, when we will go forward in our discussion, I will take you in detail about this particular formation process, but now I wanted to give you this particular comparison, so that you can further understand that which organization you will choose for your startup, when you are starting your startup itself. So, the first one which I have taken is a proprietorship, and in case of the proprietorship there is a no formal formation documents are required. Now, there is a no verification also required for the promoters of a proprietor firm. There is a no incorporation authorities who give the certification for incorporation of proprietor firm. There is a no business objective required for the proprietor firm. There is a no requirement of a statutory capital or the capital which should be mentioned into the business formation document or the constitution of that particular organization. There is a no register address is required, but for the convenience you should have a registration office, and that is what, or register address, that is what I have written, that yes, for the convenience, but there is no legal requirement. And at the same time there is a no law which governs the formation of proprietorship. So, there is a no law for the proprietorship. So, you are free to start your proprietorship firm at any point of time, and you need not require to go for any registering authority for registering your proprietorship firm. But I am going to come into my subsequent lecture and tell you that even though you are not required to have any formation requirement or any formal authority which incorporate the proprietorship firm, but you need to take a permission from other regulatory agencies to start your proprietor firm, that I am going to talk with you in my subsequent lecture. Now, let us look into the partnership. In case of the partnership, we require to have a formation document which generally called a partnership agreement. But let me tell you this thing to you, it is not necessary that you have to have a partnership agreement. Sometimes even the partnership can be inferred for the purpose of the law. But if you do not have a partnership agreement, then you are in certain disadvantage. Like if you wanted to sue somebody tomorrow for anything any wrong or any breach of contract, then in that case you cannot sue that particular person. So, it is advisable that you should have a formal partnership agreement, and that particular partnership agreement should be registered with the registering authority. So, promoters verification in case of the partnership is not required. In case of authority, I mean registering authority for partnership is varies according to the state, and in a state you will find there might be a multiple designated place where you can go to register your partnership. It is actually allocated according to the territorial jurisdiction. So, you need to find out that your place where you want to register your business, it falls within which jurisdiction. Then there is a no evidence of business capital required, that means you are not required to upfront declare that for this particular partnership you are going to have this much of amount. Register address is required, because the moment you are registering your partnership document or partnership agreement with the register of the partnership, you are required to give them a registration office address, because register is going to communicate to you in that particular address. And at the same time, it is also advisable to have your registration office, register office, because if you want to further enter into an agreement with other people in the future for the purpose of your business, then in that case you need to have a register office, because register office has to be mentioned in that particular agreement itself, and in future whenever the other person want to communicate to you, they will communicate in this particular register office. Now, let me take you to next form of business organization, that is a limited liability partnership, which popularly known as LLP, which I have told you last class also. It require a formation document, and in the formation document the law prescribe that what are the information you are required to give and what are the forms you are required to file. I am going to deal with you in detail about this particular issue in my subsequent lecture. In case of the promoter credential, yes, you need to have a partner identification number. So, whoever want to be a partner in this LLP, they need to take a partner identification number. Please remember, there is a one important concept which has been introduced in LLP, which is known as a designated partner. That means the person who is under the law authorized to deal with all the regulatory agencies. Again, I will detail it out while I am going to speak about more about these LLPs in my subsequent lecture. Now, you need to file the formation document with the registering authority, and there is a designated registers in a different state who are dealing with the LLPs. There is a business objective you need to mention in case of the LLPs. There is a need to have evidence of the business capital. That means you need to declare upfront that what kind of business capital you are starting with, and at the same time the governing laws is Limited Liability Partnership Act. But let me tell you this particular thing, that while I mean register, sometimes register business capital is important, because during the registration your determination of registration fees depend on how much business capital with which you are incorporating your firm, and at the same time you need to have a register office in case of the LLP. Now, let me take you through the next important and formal business form, which I have talked with you the last lecture, and I have dealt all the formal business form together because they govern through the single enactment called the Companies Act 2013. So, in this particular category I am going to deal with you one person company, private limited company, public limited company, and within the public limited company it is also non-listed as well as listed company. Now, in case of all the companies, whenever you wanted to register them, you need to have a formation document, and the formation documents are known as Memorandum of Association and Article of Association. In short, they are MOA and AOA. And though the promoters are not required to have any particular number for promoting the company, but what law insists today, that whoever is going to be a director in the post incorporated company, they should take a director identification number or they should have a director identification number, and they are required to quote this director identification number at the time of incorporation of the company. So, what is the type of company? It is a material. You need to have a director identification number. Now, you need to file all this formation document, or we also call this as a constitutional document, with the register of companies. Now, in every state you will find there might be one or more register of companies. It is depending on how much registration happen in a particular state. The central government decide to have number of office in number of location in that particular state. Let me give you one example. Like you might find a number of register office in state of Maharashtra. One might be in Mumbai, again you will find in Pune, or it might be in other location of the Maharashtra. And many of the time it might so happen that there is a one register office for couple of states. Like if you want to incorporate a business in Andaman and Nicobar Island, then your register office is in West Bengal and in Calcutta. So, for entire West Bengal it is a Calcutta, and at the same time for Andaman and Nicobar Island again it is a Calcutta. So, from where you are going to get who under which jurisdiction you are coming. Now, it is become very easy. You have to go to MCA website, Ministry of Corporate Affairs website, and then you can find this register office and which register office and you can find out that your area falls under which register office, because there is a territorial allocations for each register office, or there is a geographical location falls within each register office. So, you can another thing you can do, you can simply Google it and you can find out that which area or which geographical location is coming under which ROC or register of companies. Now, you need to specify the business objective in memorandum of association of a company, and this is bit stringent, because if you are not follow the business objective which you have mentioned, and you do something which is not mentioned within the business objective, then you will be you will fall within a restraint which is popularly known as ultra vires. That means, the act will be treated as ultra vires and it cannot be enforced legally. So, in case of the company, the objective clause are quite important. So, while you are framing the objective clause, you should be careful. In fact, I will suggest you to have a little broader objective clause while you are drafting your company's objective clause. Because if you are tomorrow planning to have an additional business, or if you wanted to have a diversion into your business into a related domain, and if it is not mentioned in your objective clause, then you need to amend your objective clause. So, it is advisable that you should frame a broader objective clauses. Now, you need to have upfront business capital mentioned in your constitutional document or formation document, and this is known as authorized capital in case of the companies. And as I have told you earlier also, that if the authorized capital is not amended, you cannot increase your capital. So, if you wanted to have a larger capital for your organization, you are required to amend this particular authorized capital. But again, one thing let me caution you, that if you have a very large authorized capital in the beginning or at the starting of your startup, you might be in slight disadvantage if it is not required that much of authorized capital, because as big your authorized capital is, you have to pay that much of registration fees. So, you be better careful about this framing of the capital or mentioning the amount of the capital in your in your formation document. And in case of the company, it is governed by the Companies Act. Now, let me take you to the next one, which is a society. And in case of the society, you need to have a memorandum of associations. The verification of the promoter credential is not required ordinarily, but you need to mention the address, name, and if there is any evidence like your PAN card or maybe a voter card is required to be given at the time of registration, but it is not as stringent as it is in case of the company. Now, you need to have a filing of incorporation document with the register authority, and you will find there is a register of the society in every state again, and you need to go to the register to register your society. And you are required to give a evidence of your capital. In generally, it is not as stringent as it is in case of the company, but you need to mention some amount which you are proposing that it might require for starting the venture which you wanted to initiate. Now, you need to have a register office. In case of the cooperatives, it is you need to have a incorporation document and you need to have a framing of the bylaws. You are not required to have a promoter credential verification as it is required in case of the company, but you need to have some kind of evidence of their name or their identity and the residence and everything. You need to have a filing of incorporation document with register authority. You will find every state there will be a cooperative register. Now, please remember the cooperatives are basically a state legislations. So, there might be bit of a variations of the cooperative society in every state from one to another. So, in some state they might call it as a cooperative societies, some state they might call it cooperatives, so much so forth, and there will be some kind of a variation at the time of registration, formation document requirement, maybe the business objective, mentioning of the business objective, or maybe in case of evidence of business capital. And you need to have a register office in case of the cooperatives too. And in cooperatives, as I told you before, that it is governed by a cooperative act of the different state, like one example I have given here, it is a West Bengal Cooperative Societies Act 2006. Now, the last one is relating to trust. There is a memorandum, there is a formation document is required, and the formation document is generally known as a trust deed, and then a person who is sponsoring the trust or proposing the trust, his credential is required to be verified. So, that is the reason I have said yes. Then you need to have a filing document with the registering authority. because there will be register of the trust in every state. You are required to give a objective that for which this particular trust is incorporated, but it is not the same as we understand in case of the Companies Act, because in case of the trust there is a lot of flexibility for doing things for the benefit of the beneficiaries. The evidence of the business is in the form of a corpus, and then there is a registering office for this particular trust, and the governing law in case of the trust is Indian Trust Act. So, to draw your attention that there is a different kind of a compliance requirement when you want to register your business form. In some cases it is quite stringent, some cases it is comparatively easy. So, my advice to you, choose simpler business form initially, and then later on you can scale it up to the formal business form. Like you might start with a proprietorship, then you can gradually convert that particular proprietorship in LLP, and from LLP you can convert your startup into a company like either a private company or even a public company. So, you should have a strategy in place, because legal compliance also sometimes hinder the growth of a startup. Thank you.